In a devastating blow for Prince Harry, albeit a decision taken, he's reportedly withdrawn his libel case against associated newspapers, the Mail, on Sunday. You'll remember this was the one that a month or so ago I reported that they were originally so confident that they tried to strike out the defence and have judgment in their favour without even going to trial. That application was defeated, and the judge ordered that there was a real prospect that somebody could genuinely hold the belief that he and those working with him were trying to mislead the public. Let's pop back to my previous video and remind you of what I said then. This was about a month ago. The High Court has today refused an application by Prince Harry, the Duke of Sussex, to have the defence struck out, or for summary judgment, in the case against Associated Newspapers Limited. But if you're new to my channel, I'm Daniel Smith, a barrister of England and Wales. Please do hit that subscribe button if you find my content useful. I would really appreciate that. So as I seem to make a habit of saying on this channel, you may be confused as to which case this is and what it's all about. So I would like to provide you a brief summary by referring to the press summary by the Courts and Tribunals Judiciary. So this case against Associated Newspapers Limited by Prince Harry was about this article here, which said, revealed how Harry tried to keep his legal fight over bodyguards secret. Then, minutes after MOS broke the story, his PR machine tried to put out a positive spin on the dispute. So that's a reminder of what the story was about. And as you recall, this decision of the court just a month or so ago, 8th of December, the court decided that this was to go to trial. Now, you might remember that the judge said that the newspaper had a real prospect of successfully demonstrating that an honest person could have held the opinion that the claimant, Prince Harry, was responsible for attempting to mislead or confuse the public as to the true position regarding these statements. And I'll link this video in the description below so you can go watch and refresh yourself as to what I said for the rest of that video. So what happens now? Well, it appears that he's filed a notice of discontinuance of the claim. And as the Daily Mail reports at 10:06 this morning, Harry's lawyers informed the newspaper that it had filed with the court a notice saying that the Duke of Sussex discontinues all of his claim. Now, in short, this likely means that Prince Harry is going to have to pay the newspaper's costs in the region of £250,000, of course, along with his own lawyer's fees, which in total are estimated to be something in the region of £750,000. Now, this is because if you bring a claim against another party and at some stage along that process, you discontinue that claim, then those defending it have obviously incurred costs that they need not have incurred. And therefore, you as the claimant, if you discontinue that claim, are usually likely to pay all of those costs. So what is the reason for the discontinuance? Now, there is a hint as to why he might have withdrawn this case, and that is because I understand that they were hours away from the deadline for disclosure. Disclosure being the process I've talked about in recent videos, where you have to tell the other side what documents you have that might undermine your own case. And if the other side want to look at them, which is called inspection, then they can look at those. Now, these can range anything from messages, internal emails, reports, or anything like that. If they undermine your case, and of course, if they're not privileged, then you need to disclose those to the other side. Now, if they were hours away from a deadline for disclosure, whilst of course we don't know what documents they might have been preparing for disclosure, the view might have been taken, I say might because there could be all sorts of reasons for withdrawing the claim, but it might have been one of the decisions based on the disclosure documents to say, this might mean that we ultimately lose, and therefore it's better that we back out now than go all the way through to trial, which will probably be 10 times more expensive if we lose. Equally, it might just be that he's fed up of pursuing these claims and has decided to call it quits. But obviously we don't know as yet. All we do know is that the initial claim launched against the paper was that he said that it was an attack on his honesty and his integrity, whereas the Mail had always contested these claims and said it was simply journalism. Accordingly, the newspaper in its defence argued that this was just honest opinion and that an ordinary honest person might hold that opinion. And in ruling against Prince Harry's attempt to have this defence struck out, Mr. Justice Nicklin, rejecting the argument, said, "The honest opinion defence is fundamental to the protection of freedom of expression under English law." Now, at that time, it was one of 6 legal cases that Prince Harry was pursuing through the High Court against newspapers and the Home Office. And of course, since then, he won the case against Mirror Group newspapers, and he's still pursuing other cases. So it might just be that he's decided not to pursue this one, or it might be that they've come across some documents that would be for disclosure that they'd rather not disclose, perhaps because they might harm other cases, they might harm integrity in general, or they might just harm that particular case and mean that on balance it's better not to pursue it. Of course, we don't know. He may have just decided not to pursue it. But no doubt there'll be further details on this story, so please do subscribe for more. I'll link my previous video in the description below so you can go and have a refresh of what happened last month. And while you're here, here's something that might benefit you, because as you know, I have partners that support my channel from time to time, and if you've owned a diesel vehicle between the years of 2008 and 2018 of any one of these manufacturers, then you may be able to claim compensation because they stand accused of installing hardware or software which is said to manipulate the readings of the emissions when the vehicle's in a test state. What that means for you is that the representation made to you when you bought the vehicle may in fact be wrong. And if that's the case, then you've been missold the vehicle and you might be due compensation as a result. There's been over £100 million worth of settlements in the UK alone based on these claims, albeit they do deny the claims, but cases might ultimately go forward to court. And if the claims were successful, or if you receive a settlement, it might be between 25 and 75% of the vehicle price. So you can put your vehicle registration in on the website emissions.co.uk, which I'll link in the description below, and you'll see on screen right now with the QR code, and it will tell you whether your vehicle is eligible. If your vehicle is eligible, then they can run the claim for you on a no-win, no-fee basis, meaning it's not going to cost you to get them to get your claim going. And obviously you can discuss in further detail your eligibility and how to progress that claim. So once more, if you've owned one of those vehicles between 2008 and 2018 and you'd like to check your eligibility, just pop your vehicle registration in and they will do the rest for you. So I hope that's of interest to you. Please do remember to like the video and subscribe. And as always, thank you for watching.